fuel crisis and other issues. Sorry. Anyway, this will be our last interactive learning sessions, and 2 sessions of the Roman law course book will be covered today. Thereafter, we can fix a date closer to the final examination to have a discussion class. Is it all right with everyone?
Yeah, Madam.
Okay, then you will have time to go through the entire course book and what we have discussed so far. Then without studying sufficiently, it's no point of conducting a discussion class. We can discuss questions and past papers. So then you will have time to go through everything. Then come prepared, please. Then we can discuss whatever the past questions available. Okay. Our last discussion was on Roman law of obligations. In that interactive learning session, I mentioned that Roman law of obligations we are going to discuss in 2 parts. One is law of contract, second part is law of dealings. So law of contracts, of course, we have covered, we have completed discussing, and I uploaded the presentation as well. So I believe everyone must have gone through those slides and studied the course material, the contents of the course material related to the Roman law of obligations, one law of contract. So from that point onwards, we'll discuss, we are going to discuss the second part of the main topic, Roman law of obligations. Today we are discussing Roman law of dealings. I don't know whether you can recall that I briefly mentioned what are delicts. Delicts or torts in certain jurisdictions. This area of law is known as law of tort, especially in English law. They name it as a law of tort. In Sinhala we say Thoratha Nithiya. But in Sri Lanka and other countries, we recognize it as law of delicts or delicta nithiya in Sinhala, delict. So all these torts or delicts are a group of civil wrongs, not criminal offenses. All these are civil wrongs. So no capital punishment or other imprisonment or other type of punishments are imposed. So here in Roman law even, these law of delicts initially were not categorized. So here, before coming into the session, now these are the learning outcomes. All these are based on the contents included in the course material. So if you look at the learning outcomes, at the end of this session, you should be able to define what are delicts or what is a delict in Roman law. And identify the 4 delicts mentioned by Justinian. All right. So now we are discussing especially the delicts identified or recognized and highlighted in the Justinian era. Then you should be able to explain damnum, injuria, datum, and injuria, the difference between damnum, injuria, datum, and injuria. Next learning outcome is to understand the concept of quasi-delicts. Here we are discussing delicts and quasi-delicts. So in our previous session, we discussed contracts and quasi-contracts. If you can recall what we discussed in the class. Here also, where we discussed delicts as two groups, right? Finally, recognize the role of vicarious liability. This may be a new concept to you, vicarious liability. So there are three types of liabilities. Mainly, there are three types of liabilities recognized in law, not only in Roman law. Three types of liabilities. First one is strict liability. Second one is vicarious liability. Third one is absolute liability. Three types of liabilities are there. Here we are discussing the role of vicarious liability, right? So to impose culpability on a person, or before holding a person to be liable for an offense or a civil wrong conducted done by the particular person. So there are certain factors are considered, whether this person has actually committed the wrongful action and whether this particular person or the accused had the mental element, wrongful intention or wrongful mind to conduct that particular wrongful act. So those are the two elements considered by law. Without those two elements, like mental factor and the physical factor, no one can be held liable for any offense or a civil wrong, right? But this vicarious liability concept is different. We'll discuss in this session, right? When you talk about strict liability, the mental factor is not considered. If a civil wrong or a criminal offense has been committed, then law doesn't look into whether this particular person or the accused had the mental factor or the intention, whatever the mental factor, right? So without considering the mental factor, there are limited instances where the liability can be imposed on a person, right? So those things you will learn next year, especially when you learn criminal law, you will learn those liabilities, the types of liabilities in detail, and the mental factor and the physical factor of a wrongdoer. Those things you will learn in detail in next year. Here, I only wanted to mention what are those because the word vicarious liability is mentioned here, right? So this is the lesson outline. First of all, we are introducing the session, what are delicts, right? The four delicts mentioned by Justinian. So these are the four delicts: furtum, rapina, damnum injuria datum, and injuria. Four types of delicts, right? The second part is quasi delicts. First, we introduce what are delicts, then we discuss what are the four types of delicts identified by Justinian. Thereafter, we discuss about quasi delicts. So this is the session outline. Can you see moving slides? Can everyone see slides moving?
Yes, madam.
Okay, thank you. So here, in this slide, introduction of a delict is contained. So you can go through the details. A delict is a wrongful act which provides a legal basis for an action in favor of the person injured, right? So it's a general definition. Wrongful act which provides a legal basis for an action. Legal basis for an action. Legal basis to sue in favor of the person injured, right? There must be some act by the defendant. An omission standing by itself was not a ground for liability, but where an act had been legally performed and required further acts on the part of the doer to avoid legal consequences from the omission of such further acts were sufficient, right? So mainly action is required. But when you discuss about the physical factor of an offense or a civil wrong, you can see, you will observe that actions as well as omissions are also considered as a physical act or a physical factor of an offense or a civil wrong, right? But here it says physical action is required. And further, it says the Roman law of delict was mainly punitive, although fines or compensation often double and triple damages. So those are the compensations required to pay for the person injured, to the person injured by the defendant. So often double and triple damages were paid to the injured person for the loss and the damage caused, right? Damages caused. So if you analyze this particular statement, you will see that these are punitive, but mainly compensations were required. Paying compensations was required towards the person injured, right? So that is the difference between a crime and a civil wrong. I believe in legal systems and legal writing subject, you have learned what are crimes and what are civil wrongs, right? Criminal law and civil law, difference between civil law and criminal law. What is a crime? What are the civil wrong? So all those things you must have learned. So there you must have studied that often for a criminal offense, physical punishment is given. But where there's a civil wrong, paying compensation or restitution is required, right? So all these things are relevant here. So you can recall whatever you have learned in that subject regarding the difference between a crime and a civil wrong, right? Here, these are the 4 delicts identified or recognized by Justinian. So he introduced all 4 categories of delicts to Roman law, right? Here, when you consider these 4 delicts, you can see there are civil wrongs as well as crimes, right? First one is furtum. Furtum is theft. This word is not furtum, this is furtum. Since this is Latin, it is furtum. So furtum is theft. Second one is rapina. Rapina is robbery or theft with violence. Physical violence is involved. Theft is done with violence, right? So that is rapina. Third one is damnum injuria datum, unlawful damage to property. We can discuss what are the properties considered here. The last one is injuria, wrong against a person, right? We will learn what are these 4 delicts. Here, when you look at these 4 delicts, when you take the first 2 delicts, furtum and rapina, theft and theft with violence or theft and robbery. So are these civil wrongs? Are these first 2 delicts civil wrongs?
Yeah, criminal wrongs.
Yeah. Those are criminal offenses, right? Those are crimes, theft and robbery. Those 2 offenses are considered crimes in everywhere, all the jurisdictions in the world, nowadays even, right? But in Roman law, initially all 4 offenses, all 4 delicts were identified as one category. But later on, the first 2 were categorized as or shifted to criminal law. Other two, damnum injuria datum and injuria, remained as civil wrongs or dealings. Understand? Clear? Initially, all four delicts were together. They considered as delicts. But later on, first two delicts were removed from this category and shifted to the area of criminal law, theft and robbery, furtum and rapina. Is it clear?
Yes, madam.
Okay, please answer because I'm not seeing anyone and I'm just talking to my laptop. So your response is very much appreciated. So please interact in the session because I know in the class at CRC, all are very enthusiastic and all used to ask questions and interact with me. So here this is actually totally boring without seeing anyone. I'm just talking to a computer. So I need your participation, right? Thank you. So first two offenses later on removed from this delict category and added to the added as criminal offenses, right? Other two offenses, damage to property and wrong against a person, remained as delicts.
Madam,
So,
usually
yeah.
the offenses against, I mean, criminal offenses that what will fall under that is usually the offenses against the state. No? So that will not apply here, right?
No, not clear. Your question is not clear.
Yeah, madam, usually
Yeah.
the criminal offenses, what will fall under criminal offenses is something done against, some offenses done against the state, the government. But that definition will not apply here, right? This is a different definition.
Yes, but that is the ultimate fact because criminal offences are considered as the offences against a state because of the impact, of that crime towards the society, on the society. That's why crimes are or criminal offences are considered as the offences against the state. But here, that definition and description is not applicable at this point. But nowadays, when you consider when it comes to criminal law, that definition is or that description is always applicable, right? Thank you for your clarification. Here you can disregard that the criminal offenses are the offenses done against the state, right? So here we discussed all these as civil wrongs at this point, right?
Okay, madam. Thank you.
Okay. So this is the delict of furtum or theft. The first delict mentioned in the category. Here defined by Justinian as a fraudulent handling of thing or use or possession of it. Fraudulent handling of a thing, right? So fraudulent, dishonest, right? Not honest. So dishonesty is involved here. Fraudulent handling of a thing. Thing means a good or use a thing or possession of that thing, right? So all these things are considered as theft or furtum. The rest or thing must be movable and should belong to another, right? If it is not movable, can you steal it? Can someone steal it? Immovable property?
No, madam, you can't.
No, you can't. The good or the rest or the thing should be movable, can be removed from one place to another, and should belong to another because this is a wrong or an offense done against another person because the person who is acting dishonestly is taking away a thing or a good belong to another person. In the modern context, can you do a crime of theft against a property owned by you yourself? I'm just asking a general question. Can you steal or can you do that offense of theft against your own property? පුළුවන්ද තමන්ට අයිති දෙයක් සම්බන්ධයෙන් හොරකම් කරන්න?
Madam, the plagiarism, our own writing, we duplicate something. Oh, am I making it?
No, I am talking about taking away a thing, a movable good, belong to you yourself. පුළුවන්ද?
It's very unlikely, no?
Very
It will not
unlikely. I'm asking about the modern context. So, is anyone can share ideas? What do you think? Class, what do you think?
I don't think like you can steal something that belongs to you, but well, people can pretend like someone has stolen something that belonged to them, but then that would be not theft. That would be just fraud.
You
no?
mean someone is pretending that someone has stolen on good,
Yeah.
like that?
Yeah, that would be fraud then, no?
Accusing someone else.
That means the person, the owner hides the property.
Yes, hides the
Hides the
property.
property and accusing someone else of taking away. No, I'm asking something else actually. For example, right? So don't confuse this one with this Roman law definitions and all. I'm just asking a general thing. If you give your wristwatch to repair to a technician, or if you are handing over your motor vehicle to a garage or motor mechanic to repair, right? So who has the ownership of the property, car or the wristwatch? Who has the ownership?
I still have the ownership, no?
Yeah, correct. The original owner still has the ownership. But do you owe anything after this repair? Do you owe anything towards that motor mechanic or the technician? Do you owe anything?
Yes, the fee for the service.
Yes, correct. Exactly. You have to pay whatever the fee quoted by the person, the technician, and you have to pay, and then only you can take your motor vehicle or the wristwatch back, right? Even if you are the owner, without paying that fee, you can't take. Supposing if someone doesn't want to pay the fee and stealthily take away the motor vehicle or the wristwatch from the technician without paying anything, can it be considered as a theft?
In that case, what we are stealing is basically the money that we are supposed to be paying them, no? Like we have stolen their services without paying for it.
Or rather defaulted
Yes,
the fee, right?
Yes, we have to pay the fee. Without paying the fee, we are not supposed to bring our vehicle or the wristwatch back. This is considered as a theft in modern law. If you consider the offense of theft contained in the Penal Code of Sri Lanka, you will clearly see because theft is an offense committed against the person who possesses it, not the owner. It is not committed against the owner. The current possession is with the technician. So theft is an offense committed against the possessor, the person who possesses it, not the original owner. ඒ වෙලාවට possession එක සන්තකේ තියෙන කෙනාගෙන් we are not supposed to take it back even if I am the owner, lawful owner. Understood?
It's more to do with the possession, not the legal ownership, no, madam?
Yeah, correct. Exactly. Should be done against the possession, not against the ownership, right? So those are the ones. I'm just asking a general question here. We were discussing the offense of theft in Roman law. So it should be the good or the thing subjected to this offense should be a movable property, movable good, and should be belonged to another person. So further, furtum. Within furtum, a basic distinction was made between cases where the theft was caught in the act. Furtum manifestum. In English, we say caught red-handed. Right? Thief was caught in the act while committing the act. So that is called furtum manifestum. Right? And cases where thief was caught at a later instance. So furtum nec manifestum. So which one is the which one has the gravity? Which one has the most gravity? More gravity. Furtum manifestum, caught in the act. In other instances, caught not in the act but caught at a later instance. Furtum nec manifestum. So there are two categories. So this is serious. Furtum manifestum or caught in the act of stealing is serious, right? So the punishment will be higher. Yeah, now it talks about 12 tables again. According to the 12 tables, if the manifest thief was caught stealing by night or trying to defend him with weapons, he could lawfully be killed. Oh, the punishment is very serious, right? Higher punishment is imposed. If the thief was a slave, he was put to death. No question, because that was the situation or the status of slaves in the earlier Roman society. So if the thief was a slave, he was put to death. But if the thief was a free man, he was assigned by the magistrate to the person from whom he had stolen property. Right? So he was assigned by the magistrate to the person from. It is we can't say it is actually a nocturnal surrender, but that was the way. In the later Republican period, these penalties were replaced with 4 times the value of the property stolen. Here, if you go through this sentence, you can see it is a wrong. It is a civil wrong and not considered as a criminal offense, right? It was considered as a civil wrong. See, these penalties were replaced with 4 times the value of the property stolen. The person who took the property or stole the property should pay 4 times the value of the property. So you know these paying value of the property is a remedy of a civil nature. If the offense was considered as a crime or a criminal offense, then the punishment will be physical punishment with jail sentences or like putting to death, likewise. So all those physical punishments. But here, by analyzing this particular statement, you will see if you are paying only the value of the property, then it is a kind of a civil offense, right? Civil wrong, sorry. Civil wrong. Second delict is rapina, theft with violence or robbery, right? Robbery, kollakema. In Sinhala you say kollakema. So the offense of robbery. Theft with violence become a special delict in the troubled times of Republic. Let's see, the penalty for rapina was 4 times the value of the thing. 4 times, yeah. 4 times the value. It was like the offense of theft, right? These two delicts gradually came to be considered as crimes in later Roman law. This was the one I was mentioning at the beginning of the introduction of delicts, right? These two delicts, theft and rapina, the furtum and rapina, gradually came to be considered as crimes in the later Roman law and are usually treated as crimes in modern legal systems that we very well know, including the Roman Dutch law. Since there's no pure Roman law, even in Roman Dutch law and other modern legal systems, these two offenses are considered as crimes or criminal offenses. Theft and robbery, sorakama saha kollakayama, right? So the requirements were more or less the same, like the property should be a movable property, the property should belong to another person. Those requirements are also there when establishing criminal liability against these two offenses, either for theft or robbery. Those requirements are still there. Property should be belong to another person and it should be a movable property. Can you steal a tree? Can a tree be subjected to theft in modern law? ගහක් හොරකම් කරන්න පුළුවන්. ඉඩමක තියෙන අපි කියමු very valuable calamander tree, teak, whatever expensive tree. So can a person steal it?
Can, no matter. Can
Can
steal.
come take it,
I think.
Because it is not a movable property, it is fixed to the ground, right? Whatever fixed වෙලා තියෙන්නේ. So can a person, because the property should be a movable property, right? What will happen if that particular tree is fallen due to a storm, or if a person cuts that tree and takes the wood away? What will happen then? Then those requirements for the offense of theft are fulfilled, right? So once it is removed from the ground, or the way it is fixed to the ground, then it will be subjected to the offense of theft, because it is movable. It will become movable after falling due to a storm, or if someone cuts it, and then the property or the tree is property can be subjected to the offense of theft, right? Understood? පොළවට fix වෙලා තියෙනකල්, පොළවට fix වෙලා තියෙනකම් you can't steal it, right? You can't do the offense of theft against a fixed property, but as soon as it is removed from the ground, it will be subjected to such offense, right? ඒක වෙන්න පුළුවන්. ගහ කැපුවට පස්සේ හරි storm එකකින් කුණාටුවකින් වැටුණාට පස්සේ හරි ඒක හොරකම් කරන්න පුළුවන්, right? But prior to that it was not a movable property. එහෙම වෙන්න පුළුවන්. Even a building, right? Even a building after dilapidation, so anyone can steal like tiles, wooden fixtures, whatever, the thresholds, windows, doors, anything. But when it is fixed, it is not subjected to the offense of theft, right? Yeah, sorry. The last sentence also we discussed previously. Damnum injuria datum and injuria were adopted by the Roman Dutch law of delict, and today all delictual liabilities with a few exceptions are connected to one another of these two offenses, right? Damnum injuria datum and injuria, right? So those stayed as civil wrongs up to now. The previous ones gradually shifted from this same group of delicts, and nowadays they are considered as crimes or criminal offenses. The latter two are still considered as civil wrongs. So this is damnum injuria datum, unlawful damage to property, right? Unlawful damage to property. So there's a special legislation, Lex Aquilia. You must have heard that word before, Lex Aquilia. Law in this area was mainly based on the Lex Aquilia. This statute suppressed the 12 tables and earlier laws dealing with damage to property. The Lex Aquilia enacted the following way. Anyone who wrongfully killed a slave or a four-footed animal belong to another should be liable to pay the owner the highest value of the slave or animal assessed during the previous year. Highest value of the animal or a slave assessed during the previous year. That was the value required to pay. Highest value of the previous year, particular slave or animal. So wild animal, you know, no one can own wild animals, right? You have learned all those things. So tamed animals or domestic animals, such as horses and cattle, lamb, those are considered as animals belong to a particular person, right? So anyone who wrongfully killed a slave or a four-footed animal belonging to another should be liable to pay this much of compensation, the highest value of the animal or the slave during the previous year. So is it clear for you? So what is the meaning of this part within the bracket without cause of excuse recognized by law? Anyone who wrongfully killed. Wrongfully means without any reason or without any excuse. That's the meaning of wrongfully. If you are doing it in a reasonable manner, there should be a cause or excuse. If the animal or a slave acted violently or acted harmfully, likewise, then there may be reasons to kill or destroy that person, the slave or the animal, right? If the slave or the animal becomes violent, then there can be reasons, there can be excuses to justify the killing, right? Or harming the thing. Here it says without cause or excuse, any reasonable excuse recognized by law. එහෙම reason එකක් නැත්නම් killing a slave or killing an animal, a domestic animal is considered as an offense under this category, damnum injuria datum, unlawful damage to property. So properties, the slaves and animals also are considered as properties, right? මේ වගේ property එකක් විනාශ කරපුවාම that is the way law considered that act, right? Is this one clear for you?
Yeah, madam,
Clear,
it's clear.
no? Oh, okay. So all these descriptions are relating to the same civil wrong, damnum injuria datum. Anyone unlawfully doing damage to any property other than to slaves or cattle by wrongfully breaking, burning, or destroying. So here we can see the idea here is to damage done towards another property except animals or slaves, like houses, buildings, cultivations, harvest, so those things. So other than slaves or cattle by wrongfully breaking houses, burning houses, or cultivation, harvest, or destroying anything should be liable to pay the owner damages computed on the value during the preceding 30 days, previous 1 month of the object injured or destroyed, right? The previous instance, if a person damaged or killed a slave or a domestic animal, then compensation was the highest value of the thing during the previous year. Here, highest value of the thing or the property during the previous 30 days. We can say 1 month, previous 1 month or previous 30 days. So that is the compensation required to pay. What is the word dominus mean here? Action by the dominus. As to the person who could bring an action, the statute only contemplated action by the dominus. Who is dominus here? How the dominus kila kiyane metan? Only actions can be brought by the dominus. Can you think any?
Owner.
Owner, exactly, owner. Dominus, right? Swamiya. In modern law, even if a person has a lawful ownership, it says ut dominus, ut dominus. Ut dominus is in Sinhala swamitva bhuktiya, right? So you are possessing and enjoying the property as the owner, ut dominus. Here the dominus, only the owner of the property can bring an action or go for litigation. The remedies were the statute. Remedies of the statute were extended by actionis utilis and actionis in facto to a bona fide possessor. Who is bona fide possessor? Not the owner, bona fide possessor. Sadbhave mukti vidina kena. Bona fide, in good faith. Bona fide is in good faith. If you are possessing a property in good faith, you are not the owner or you are not the dominus, but you are a bona fide possessor. Or usufructuary or a pledgee or anyone having a right in rem if his interests were prejudiced, right? So later on, remedies of the statutes were extended later on. Initially, only the owner could go for litigation or bring an action. But later on, this facility was extended towards the bona fide possessor, usufructuary or pledgee, or any other person who has a right in rem. Right in rem kiyanne mokadda? What's the meaning of right in rem? Right against the entire world. There are two types of rights: in personam, rights in personam, rights in rem. So servitudes, what are servitudes? You must have learned. Yes, you have already learned all those things, servitude. So what is a servitude? Right in rem or right in personam?
Persona.
Is it correct? Servitude? Servitude is a right in rem.
Rem, no, madam. Many can make use of
Yeah,
that.
many can use, and it can be exercised or enjoyed against the entire world. Rights in rem. If you say in personam, you can use it only against one person. Servitudes, if the original owner sells the property, we have the right to enjoy that particular servitude against the new owner as well. So how many owners, it doesn't matter whether the tens and 20s and hundreds of owners come in future, we have the right to enjoy that particular servitude. Am I correct? හරි නේද ඒක? ඒ property එක කවුරු ගත්තත් I can the person who was enjoying the servitude can enjoy it continuously. ඕන වෙනස් වුණා කියලා servitude එක වෙනස් වෙන්නේ නැහැ. So this is a right in rem. In rem. Right? Not in personam. In personam ඒ ඉන්න එක්කනට against විතරයි. If the person sells the property to another person, then the servitude stops, no? එම වෙන්නේ නැහැනේ. So please read that part again, right? So the right to litigation was extended to some other positions as well. Not only the lawful owner, not only to the dominus. This statute, what is this statute? What is this statute? Lex what? Here, Lex Aquilia, right? We are talking about here, this statute means Lex Aquilia. The Lex Aquilia only gave remedies if there was a direct killing or damage to slaves or animals of a certain kind. So, only gave remedies, not punishments. Anti ගෙවන්න විතරයි උනේ. Punishments දුන්නේ, no jail sentence, no beheading, nothing, right? No nuptial surrender, nothing. Only gave remedies in the form of compensation. So the last delict is injuria, wrong against a person. Willful infringement of the rights to personal freedom, personal safety, or reputation of a person. So these are the ones. So here, injuria is still existing in modern legal systems as well. There's a specific action called actio injuriarum. It is for the action of defamation. Actio injuriarum. In nowadays even, that is the name of the action available to a person who is affected by this type of defamation, right? Actio injuriarum. Generally, the injuria means something contrary to law, a willful infringement of the rights to personal freedom, personal safety, or reputation of a person. In this case, intention to injure is essential. All right, intention is essential. The person must have done it purposely. Intention should be there. If it is done without any wrong intention or harmful intention by mistake or by an accident, right? Then it is not considered as injuria because the intention factor is very important here. Should be done purposely, intentionally, right? Whereas the damnum injuria datum, negligence is sufficient. So damnum injuria datum, no requirement of intention. Negligence තිබුණත් ඇති. Intention එකක් තියෙන්න ඕනේ. Only acted in negligence was sufficient to prove damnum injuria datum because you are harming properties. But here, to harm a person's personal freedom, a person's personal safety, or a person's reputation, to harm any of these, there should be an intention to create or make harm. So that the law especially considered that factor to establish liability against a person, right? Damnum injuria datum, compensation is calculated on the basis of actual pecuniary loss caused, whereas in injuria, this one we know, damnum injuria datum, if it is for a slave or an animal, the highest value of the previous year. If it is a property, highest value of the property during the previous 30 days, right? So that was the way. But in injuria, damages are given as a solatium or the compensation. Damages are given as solatium for the injured feeling of the plaintiff. Here, damages are given as a solatium for the injured feeling of the plaintiff because this is a damage towards a person's feelings, right? And punishment, punishment for the insulting behavior of the dependent, right? punishment. So, punishment for the insulting behavior of the defendant. We'll see what are those punishments, right? Injuria. Mainly damages were required to pay. This is the highest or serious level of injuria. Atrox injuria. Injuria may be serious where the act was especially outrageous on account of these things. The nature of the act, whether it is just shouting or throwing stones or attacking with a weapon, or nature of the place where the insult was offered, or the rank or profession of the person injured, right? So what do you mean by these? Injury will be, the injuria or the harm will be serious if the act, wrongful act done by the person is very serious, or nature of the place where the insult was offered. So what do you mean by that? Nature of the place. If the insult was done in a public place, in a public market, at a theater, or in a public gathering, in a festival, wherever, so that is considered as more serious because that is done by in front of so many other people. So this the injury is or the harm is considered as much higher. ප්‍රසිද්ධ තැනකදී නම් කරලා තියෙන්නේ, then it is considered as a injury or the harm of high grade, right? So the rank or the profession of the person injured, whether the person is a plebeian or a senator or a priest or a high magistrate, a judge, a consul, right? So those things considered. If it is an ordinary person or a plebeian or any other ordinary person, then the harm is considered as somewhat lesser, right? But the person's profession or the rank is higher, the high military officer, right? So those things, the instances were considered as the high level of injuria, right? ඒ වගේ ලොකු කෙනෙකුට හානි කරොත් ඒක තද බල විදියට සැලකුණා, right? Nature of the place and the rank or the profession of the person. Like if something, some defamatory thing has happened inside a person's house, so that is considered as a lesser level of injuria. But if it happens in a marketplace or public arena, then considered as a serious injuria. Okay, understood? Clear, everyone? Is it clear to everyone? I can't hear answers now. Are you all there?
Clear.
Right, clear, no? So please go through the lesson, and it will carry more details. So you can do further reading as well. So these are the main points, the measurement of the level of injury, right? Whether it is a higher level of injuria or lesser, right? So these are the criteria used in ancient Roman law. The concept of injuria was enlarged by the jurists. It was no longer limited to physical violence, and it came to embrace every kind of aggression upon a man's person or personality. A man's person or personality. What do you mean by that? Person or personality. A man suffers injuria not only in his own person, but in the person of another. An injury offered to a slave gave a master. All right, so it was extended, right? injury offered to a slave gave a master a course of action, right? Actually, the injury has not happened against the master, but since he is the owner of this particular slave, uh, he has the I'm sorry, there was a disturbance. I'm sorry, I had to mute myself. Can you all hear me now? Can you all hear me?
Yeah, yes, madam, we can
Okay,
hear.
okay.
Madam,
Okay.
once when you say person or personality, does that mean sort of character assassinations?
Yes, character, reputation. Personality is reputation. Person is physical person. Personality is more uh, like reputation and his like recognition in the society likewise. So if something is done at a marketplace or a public arena, that is, let's say someone hooted or someone threw stones or someone uttered any defamatory or shameful words, right? So those things are considered as the wrongful things done against uh, a man's personality, right? There's no physical harm, but it is defamatory because it's harming his reputation and the recognition he has in the society, right? Okay.
Yes, madam, clear. Thank you.
Okay, okay. Here, this explains about the expansion of injuria, right? Roman juries broaden the concept, not limited to physical violence. So all those things I mentioned here, the same things, of course, same things, concept of injuria and like by the jury, same things are mentioned here in point form. So any aggression, defamation, insults, harm to reputation. Those were the things. Master could sue if his slave was injured, right? So that means someone is harming a property belong to a particular master. So the master was able to sue against the wrongdoer, right? All these things are important uh, when it comes to the offense of injuria, the civil wrong of injuria. Initially, it was not expanded up to this level, but later on, it was like with the contribution of the jurists, the expansion of injuria has happened, and lot of like not only physical violence but other damages were also covered under injuria, like defamation, insults, harm to reputation, so on and so forth, right? So now we have now so far discussed the delicts or civil wrongs identified by the Roman law. Here, the second part of it is quasi-delict. Let's see what are the quasi-delicts, because in our previous session we discussed about contracts and quasi-contracts. Here, delicts and quasi-delicts, set of civil wrongs. Quasi-delicts were the last category in the Justinian's classification of obligations. Yes, Justinian's institutes explain some obligations could not properly be called delictual, and yes, they are not fully delictual, and yet they did not arise from contract. So they are neither the contracts or the delicts directly. Therefore, the wrongdoer's liability seems to be quasi-delictual. In singular, you say arda delicta. Arda delictamai vagakima. Givisum saha arda givisum. Here, delicta saha arda delicta. And a pecuniary penalty could be imposed on him at the judge's discretion, right? Only pecuniary penalty, not a physical punishment. So these are wrong of a miscellaneous character and consist mainly of instances of vicarious liability. I mentioned the word, this term at the beginning of our discussion, vicarious liability. That means liability that a supervisory party, such as an employer, bears for the actionable conduct of a subordinate or an employee, based on the relationship between the two parties. Here, actually, this relationship is a legal relationship, right? That word is important here, based on the legal relationship, let's say like that. Legal, right? Not a normal, ordinary relationship. Yes, based on the legal relationship, right? Employer and employee, master and a subordinate, captain of a ship and his crew member. Likewise, so this concept of vicarious liability is still existing and exercised against the against masters of any place, right? So these are also considered as civil wrongs. Let's say, who are these? What is this legal relationship of masters and subordinates? Likewise, so let's say what are the legal relationships. So first one is judex qui litem suam fecerit, right? Judex is a judge, qui litem suam fecerit. A judge could be sued for damages if he gave an unjust decision through bias. Unjust decision through bias, incompetence, or corruption. Those things were there during the ancient Roman law as well. Corruption of judges, unjust decisions, incompetence, competency of judges, all those were existed in the ancient Roman law as well. So, judge could be sued. A judge, even a judge could be sued for damages happen if he gave an unjust decision through bias, incompetence, or corruption. The action is vicarious in the sense that the judge takes over the liability of the party benefited by his impropriety, thus making the cause his own. What does it say? Judge is delivering an unjustful decision or biased decision, or judge is incompetent, or deliver a judgment based on corruption, taking bribes, right? Judge is vicariously liable because due to this unjustful judgment, the unreasonable, unjustful judgment, one party is benefited, right? It is not reasonable. Only one party is benefited due to the action of this particular judge, right? So that is not justice. That is not considered as justice. So that is unreasonable, unjustifiable, right? So unlawful. Therefore, this judge will be held liable because one party is getting benefited due to his unjustful action. So he will be vicariously liable. He is not getting any benefit. Judge is not getting any benefit unless he takes bribes, right? Bribes gatte natta. So judge is not benefited by this particular judgment, but one other party is unduly benefited due to this wrongful judgment. Because of that fact, because of that reason, judge will be held vicariously liable for his own action, right? Judge judge is not getting any benefit. Only one party is getting benefited, not in a proper manner. Judgment එක වැරදිනේ, වැරදි judgment එකක් දෙනවා based on one of these reasons. මෙන්න මේ වගේ දේවල් නිසා giving an unreasonable judgment, right? So මේ judgment එක නිසා one party is getting undue benefit. So for that, a judge will be held liable කියලා තමයි Roman law වල කියන්නේ, right? Is it clear to you? The first one, judex qui litem suam fecerit, action of a judge. Second one, actio de effusis vel dejectis. Actio de diffusis vel dejectis. All these are Latin terms. So here in this picture, you can see where something is thrown or poured out from a house or a way commonly used to the damage of the passerby or property. The household is liable even if the act was done without his knowledge or consent. What does it mean? Can you explain in another way? Can you explain? Something is thrown or poured out from a house. Can anyone explain in other words? Supposing my child or a member of my family is throwing something very let's say broken pieces of glass or hot water towards the road below. I may be not knowing anything, or I may not be at home even. Right? So, but still I will be held liable. I don't have to do anything, any kind of such action, but if a member of my family, if a person in my household does this particular harmful act, to pouring hot water, pouring harmful chemical or some hazardous substance towards the road, damaging passing by people. Is it clear for you? Is it clear? I'm not doing anything wrong. I don't even know, but still I will be held liable. Vicarious liability, right? I will be liable for another person's action. Actio de effusis vel dejectis. No one is answering.
Clear, madam, it's clear.
Okay. So these offences are, these civil wrongs are still here in the law of delict, right? You are not supposed to do any kind of these actions, then you will be held liable. That's why you have to be very cautious. Right? Action was for double the amount of damage done. Double the amount of damage done. Judge assessed the damages taking into account medical expenses, loss of employment, etc. Right? So judges considered what was the what were the medical expenses occurred, or what was the damage occurred due to a loss of employment. Let's say by pouring hot water on a person, not purposely maybe, but that burn injuries will prevent that particular person involved in his employment for a long period of time, right? Likewise, so loss of employment. So judges considered all those things before finalizing or deciding the amount of compensation to be paid, right? Next one is aptio de positis vel suspensis. An action could be brought against a person who kept things suspended from a building over a public way to the danger of passers-by. Hanging things. Person who kept things suspended from a building, like maybe plant pots, ladders, or some other scaffolding or something hanging from a house, endangering the passers-by. A master of ship. So these are the people who are vicariously liable for their subordinates' actions. Master of a ship, an innkeeper or public stable keeper was liable for theft or damage caused by his employees or slaves, right? So this is the nature of vicarious liability. Is this one clear for you? Master of a ship is not doing any harmful thing, but a member of his member or members of his crew creates any harm or damaging thing, the master will be held liable. And an innkeeper, Tanayamaka, a manager of a guest house, an innkeeper. Even nowadays, those offences or civil wrongs are liabilities are available in law, right? So in ancient Roman law, innkeepers were held liable, masters of ships were held liable, public stable keepers were held liable for the damages caused by slaves, employees, or subordinates, right? So those are the nature of quasi delicts. So this is the present situation. Roman law concept of quasi delicts was adopted by the Roman Dutch law. Our discussion reveals that most of the concepts in the Roman law of obligations were adopted by the Roman Dutch law and are still applicable in the modern context. Is it clear? This is the end of our session, right? End of this session. Do you have any queries or things to be clarified from me? Do you need any clarification from me?
Madam, earlier
Yeah.
it is mentioned that injuria one can the person can suffer it or they can have it on behalf of another person. That was not clear to me.
Which one? Injuria?
Yeah, injuria.
Yes, yes. We'll go to the slide. Right here. Which part?
It said a man suffers injuria not only in his own person but the person of another. Was that statement specific to the slave master relationship or in general?
Yes, yes. Slave master relationship.
Okay.
Right? Or sometimes it might be extended towards a child under patria potestas. Likewise, we can define it. Mainly towards the slave and master relationship, but we can assume that it can be extended towards the other levels as well.
Thank you.
Okay. So we have another half an hour in our session. We can start the next topic, the final session of the course book, Roman Law of Actions. But I don't think we will be able to complete it today. So we have to arrange another interactive learning session as well, right? Shall we start that session today itself, or shall we start it in the next interactive learning session? What do you think? What do you think?
Madam, if we won't be able to complete it today, it will be better to start it in the next day. No?
Next session, okay. Let's see whether we can arrange another day school on next Saturday or so, because our scheduled lectures are over as far as I know. Anyway, I will check and let you know. So this next session will be can you see my new slides?
I can still see the previous one.
Sorry?
We can still see the previous one.
Previous
It
one.
says-
Okay.
Yeah.
Okay. Roman law of procedure, Roman law of actions. So this is going to be the next session. Here, actually, this session, of course, explains the procedure or the litigation procedure, the procedure for Roman law of actions, right? So it explains only the procedure. I don't think we have much things to discuss. Anyway, we'll, as we have discussed each and every session in the course book, I think it is better to discuss this session as well as the final session. So this will be the outline, introduction to the Roman law of procedure. Then what is the definition of Roman legal procedure and Praetorian remedies. What was the legal procedure available in the ancient Roman society? And further, the session will discuss Praetorian remedies. Have you ever heard the word the remedies introduced by the chancellor in equity and trust law? Principle. When you
Yes.
study principles of equity, you must have learned remedies, legal remedies introduced by the chancellor based on the just and equitable principles, right? So these Praetorian remedies are also kind of such nature, right? Such nature and remedies introduced by, based on the natural justice, right? Those things will also discuss. So here these are the expectations in this session. You will learn the law of procedure, the law relating to actions in Roman law, law relating to actions, how to sue, how to initiate litigation, what is the procedure up to the delivery of judgment likewise. So it further discusses the three types of procedures, right? So actually in this session, it contains mainly the description of these three procedures, how it happened, right? Leges actionis, formulary procedure, and the cognitio extraordinaria. So these three are the main procedures available. So this is the most important procedure they are in. Formulary procedure. In Sinhala, you say Sutranukula Patipatiya, formulary procedure. And the last one is cognitio extraordinaria. Those were the procedure for civil trials, right? So thereafter, the session will discuss the importance of prior to orient remedies, right? So what were the remedies? Are they still available or existing in the modern legal context? Likewise, all those things we'll discuss. So I will wind up the session for today. For next session, I wish if we can have a physical in-class session to discuss that final session of the course book. Anyway, we'll see if that is not possible. We'll have it online. And then I will wind up the session. I will share these slides, upload these slides to the LMS page. And thank you very much for joining. I wish you a happy weekend, happy and peaceful weekend, everyone. Thank you for joining.
Thank you, madam.
Thank you, madam.
Thank you, madam.
Thank you, madam.
Welcome.
Thank you, madam.
Welcome, everyone. I will end the session.